Look at these 3 words written larger than the rest, with a special pride never written before or since. Tall words proudly saying, "We the people."
All right, I planned to come tonight not knowing the Supreme Court was going to be releasing 2 of the biggest decisions in our generation, perhaps even our lifetimes, the Thursday and Friday beforehand. So I did have to rewrite most of my remarks, but I think that you'll probably appreciate that a bit more. Before I begin, this is sort of the customary disclaimer I have to make. Nothing in this speech constitutes legal advice. It's for educational purposes purely, legal education. If you want legal advice, we are more than happy to give you a free 30-minute consultation at your convenience. We can do those over the phone or in person. So if you want our contact info for that, by all means contact us. So I was reading the New York Times on Friday, which is never a great decision. You know, that's you always end up regretting reading the New York Times when you do that. But I came across an article, and that article was talking about how abortions' rights had been affected by, of course, the Dobbs decision. And at one point, what that article had to say, what the author had to say was, quote unquote, "The sudden importance of laws that were written before women had the right to vote has sent legislators, activists, and abortion providers scrambling to understand the implications." You know, it's not common that the court will actually, it's incredibly rare that the court will have an opinion broadcast ahead of time prior to publishing that opinion, but I don't know why they had to scramble in particular for this particular opinion, but I guess they did. But 2 things really struck me about this statement from the New York Times. The first one, this is a good one. We've got them on the back foot for once. We're not playing response to what they're doing, they're playing response to what we are doing. That is a huge advantage. We've got to move on that. And the second thing that struck me, and this is really where I think the Lex Rex Institute's focus is directed, is, let me look at that again. So it said the sudden importance of laws that were written before women had the right to vote. Well, what does that imply? It seems the left, or New York Times at least, really doesn't like things that are old. You know, that's sort of a pejorative comparison there, written before women had the right to vote, which I guess suggests that any law prior to a certain date must have some sort of expiration date on it, like the milk at the grocery store. You know, I'm here to suggest that's not true. I'm here to suggest that just the opposite is true. The longer something has been around, the more we can trust that thing. And that's the way our founding fathers understood our Constitution to work. You know, I think that when our Constitution was ratified, I think there's sort of a misconception that the Constitution created something out of nothing, in much the same manner the French Revolution did. You know, did away with the old order and installed a new one. Our founding fathers, really, rightly understood, were conservatives. They liked the rights they had as Englishmen, and they didn't like the way the Crown had taken those away in the last few years prior to the War of Independence, and they stood on those rights and they enforced those rights. They're the traditional rights that had existed for Englishmen for centuries prior to that. What I want you guys to keep in mind, so over the past few days, I'm sure that you've seen on the news that people are protesting the Dobbs decision. And they're protesting it in California as though it even affects anything in California. I'm not sure they understand that. I'm not sure they're particularly educated about any of the legal issues that are facing our country right now. But don't get discouraged just because their voices are louder. Edmund Burke, a member of the British Parliament, one of the men who spoke in favor of the American colonies prior to independence and urged the British Crown and Parliament to make some kind of a deal with the Americans to make us go away, because you can't afford to lose these American colonies. What he had to say is he actually compared the situation of people complaining a lot, because I guess the anti-American voice was a lot louder in Parliament at the time. And what he had to say is that when you walk through a field, and there's tons of cows in that field, the only thing you hear is crickets, and you hear lots of crickets. And you've got to be pretty darn stupid to assume the only thing in that field is crickets. The loudest voice is not the only voice, it's not the most important voice, and it's not the only one that we should listen to. Public outcry is to be expected on a matter like this. Seriously, don't treat it any differently. I don't know how many of you are cat owners. I'm a cat owner. Don't treat it any differently from when your cat tries to wake you up in the morning. Really, they're used to getting what they want, and they cry when they don't get it. That's all that's going on here. What's far more concerning is that these cries of distress are not coming just from the folks that you see protesting outside the courthouses. They're coming from people who are charged with upholding the laws of our nation. That ought to be a very disturbing thing. I don't know if you guys remember a few years ago, I've actually forgotten which decision it is now, one of the ones that had to do with the Trump administration's immigration policies. And afterward, President Trump commented, I think the court made the wrong decision on that. He was run over the coals for that. Well, look what's going on now. You don't have to look too far. Merrick Garland, current head of the Department of Justice, said, what he had to say was, the Justice Department strongly discourages the court's decision. This decision deals a devastating blow to the reproductive freedoms in the United States. It has an immediate and an irreversible impact on the lives of people across the country, and it will be greatly disproportionate in its effect, with the greatest burdens felt by people of color and those of limited financial means. That's the head of the Department of Justice, the person who is responsible for enforcing the laws of the United States. I'm not sure why he felt the need to make that decision. I think maybe just to remind everybody of how good a decision the American people made in never putting him on the Supreme Court. But for whatever reason he felt the need to say this, obviously that is totally unbecoming of his position. He would do well to remember the words of a man like James Wilson. I don't know how many people here have heard of James Wilson. Not Woodrow Wilson. We don't like him. He's not a great guy. But James Wilson is one of our founding fathers. He was actually a signer of the Declaration of Independence. He also was at the Constitutional Convention, was instrumental in a number of provisions of the Constitution. He's the guy that you can thank for the Electoral College, which I know the left tends not to like too much either these days. But what he did was, after our Constitution was ratified, he became a justice of the Supreme Court, and while he was justice, he also taught a program where he said it's really important the American people understand our law. They understand the Constitution. So he set out a program to teach them in a university context, and as part of his notes, part of his lecture notes on that, he had this to say: how can a society be maintained? How can a state expect to enjoy peace and order unless the administration of justice is able and impartial? Can such an administration be expected unless the judges can remain dignified and independent characters? Can dignity and independence be expected from judges who are liable to be tossed about by every veering gale of politics, who can be secured from destruction only by dexterously swimming along with every successive tide of party? Is there not reason to fear that such a situation, the decisions of the courts would cease to be the voice of law and justice and would become the echo of faction and violence? That is the only reason the Dobbs opinion was leaked prior to the court's analysis. People were trying to put pressure on the court to instead be swayed by the gale of politics and not by the voice of the law. That is a dangerous notion. When you have the head of the Department of Justice also advocating for that, that is doubly dangerous. When the court made its decision in Roe and stuck to that decision that it had in its draft, it fundamentally inverted the system of government that the Founding Fathers had put in place. That decision in Roe v. Wade in 1972 was one which rejected the idea that legitimate power derived from consent of the governed. The decision was little more than a reversion to the divine right of kings, except that Justice Blackmun was our king instead of King George. On Friday, the Supreme Court stopped that trend dead in its tracks. It upheld the law, not the opinion of men. Judges are, and always must be, subject to the laws they interpret. Does not work the other way around. Our Founding Fathers understood this very, very well, and the idea came from a long tradition that predated them and which they had studied in depth. One of the men who was most instrumental in that legal history was a guy by the name of John Locke. He was an English philosopher. He actually wrote the constitutions, the charter constitutions of the states of, or would eventually become the states of North and South Carolina. A lot of people don't know that, but what he said is that freedom of men under government is to have a standing rule to live by, common to every one of that society and made by the legislative power enacted in it. A liberty to follow my own will in all things where the rule prescribes it, and not to be subject to inconstant, uncertain, unknown, arbitrary wills of other men. That's from John Locke's Second Treatise on Governments, one of the very most influential documents to our Founding Fathers. What John Locke has said here, that's all the court did on Friday. The court returned a political decision on a political issue, namely that of abortion rights, to the legislative power, where it belongs, and specifically the legislative power of the states. The people's chosen representatives, and of course, the only legitimate proxy for the people's political power. We actually, we need donations to be able to run our caseload, to be able to represent our clients, and we also, our passion is educating the American people in the history of our laws and traditions. So we figured, why not kill two birds with one stone? And we're actually selling a couple books that are on that subject here today. If you make a donation to us of $25 or more, you can have your pick of one of these three books. One is Neil Gorsuch's A Republic, If You Can Keep It. Title is based on a Benjamin Franklin quotation where he said, somebody asked him as they was leaving the Constitutional Convention, "What have you given us, sir? A republic if you can keep it." And Neil Gorsuch, I think, very eloquently talks about the respect for the rule of law. One of them is that John Locke's second treatise on government, as well as his first treatise on government, which is much neglected. That one's worth reading too. And then, of course, for those who haven't read it before, it's never too late to read them. It takes less than an afternoon. Our Constitution and Declaration of Independence. I cannot recommend this particular one more highly. But that's not the way the left has seen this opinion. The outcry has been, well, frankly, ridiculous. In fact, just look at what the president himself said. With this decision, the conservative majority of the Supreme Court shows how far removed they are from the majority of this country. They have made the United States an outlier among developed nations of the world. Well, I'd like to address his second point first. If we're an outlier next to places like France and Canada, there's at least got to be something to be said for that. That's not a bad thing. But to his first point, his more significant point, that they've removed this decision from the majority of the country, quite the contrary. They've given it to the majority of the country. We can decide whatever we want on this issue now. And more broadly speaking, to the idea that the court ought to be subject to the majority opinion at all, he could not be more wrong.
He's an idiot.
Well, I wouldn't call him an idiot. I would say that I would hope the kinds of things he was saying would only be the opinions of senile old men, but I've heard other people say them too. I didn't say Biden was a senile old man. That's if you inferred that, that was you. But
Hard to believe he's an attorney.
oh, yeah, it is hard to believe he's an attorney.
But even attorneys tend to lose the sense
Yeah.
of law.
The consideration of whether or not the majority agrees with the court's decision could not be less relevant to what the court decides. The court does not rule on the basis of public opinion. They are not elected representatives. The court rules on the basis of written law, and specifically the Constitution. The Constitution just does not say a thing about abortion, except for, you could argue there's words in the preamble about that, but I'll get to that in a few minutes. Secondly, on the issue of gun control, I don't know if you guys heard on Thursday, I think this would have been huge news if not for the decision that came out the next day. There was a decision overruling a New York state law that required a showing of need in order to get a concealed carry permit for a gun. The court rightly upheld Second Amendment rights, saying that you don't need to show need to exercise a constitutional right. Rosa Parks didn't need to show that she needed to sit on the front of a bus. You don't have to show need that you show need to get a concealed carry permit. So both of these states were correct decisions. So what happens now with both of these things? Well, with guns, states can no longer require a showing of need in order to purchase a firearm. We do not know what California will do on that subject. We don't know if they'll continue to have a provision in the form asking for a showing of need. As of Friday, they still did. And for anybody, I encourage people in every county, because ultimately it's at the county level, county sheriff who approves these concealed carry permits. I encourage anybody, apply for a concealed carry permit, and when you get to that box that asks for need, if they do end up keeping that, which I suspect they will, write, exercise of my Second Amendment right to bear arms. That's your need. That's your showing of need for getting a concealed carry permit. And if they do end up denying any of these, which God willing, they won't, but if they do end up denying any of them, we want to make sure that we have litigants prepared to be able to defend this right that the court has already secured. Because that's how we're going to do it. We're going to need people in all the counties to be able to challenge this, to show they are not actually upholding this decision of the Supreme Court. I actually looked at this the other day, and I had my friend's idea. He found it's a picture made out of a bunch of symbols and backslashes and asterisks and all kinds of symbols. And you look at them and you put them all together, and it makes a middle finger. I figured, put that in the showing of need. What need do you have for a concealed carry permit? Well, give them the middle finger. I think they'll understand exactly what you mean. So, what's the practical fallout of the case regarding abortion? What's the practical fallout of the Dobbs decision? Well, in California, nothing yet. In other states, they have the right to pass their own laws respecting abortion. Whether they want to restrict abortion rights or grant abortion rights, it's up to them. State legislature in California has already announced its intention to pass a constitutional amendment in this state that will protect a woman's right to an abortion. That's how they phrase it. You look at the actual text of that amendment, which has already passed the Senate. It originated in the Senate. They're talking about going through the Assembly tomorrow. But you look at the text of that, it gives an unrestricted and unfettered right to abortion at every trimester, every stage of the pregnancy. Now, I know that California is a pretty strongly pro-choice state in terms of people's opinions. Most people are not in favor of an unfettered, totally unrestricted right to abortion. I think this is where the battle has to lie legislatively. We cannot let them set the narrative on this constitutional amendment. They've got a lot of political momentum going in their favor because they're going to be saying, we want to protect the right to an abortion. Don't let them use that language. We have to define what this amendment is. What this amendment is unrestricted right to abortion, a right to abortion at all trimesters. And we can oppose that. I think we can win on that. What else do we do? Well, in California, the fight is, of course, at the state level. And it's hardly time to rest on our laurels. Now is the time that we need to start fighting. The fight starts now that we won the Dobbs decision. It does not end here. Abortion is far from a settled issue. And there will continue to be challenges with respect to abortion. Things like a few years ago, I worked on the NIFLA case that was mentioned in my introduction, I believe. And what that case had to do with was the state was compelling pro-life family planning centers to basically provide propaganda for getting an abortion. So if they go to a pro-life family planning place, you got to hand them a brochure that says, look how great an abortion is. You really ought to get an abortion instead. We challenged that. We got that overturned. Challenges like that will continue to exist, but the latitude for us to be able to contract abortion rights has vastly expanded because of this decision. In fact, I think there's a plausible argument. I guess take a step back. There is currently very, very little federal precedent on the abortion matter because controlling law was Roe and Casey. Both of those have been overruled. So it's sort of an open question now. Well, a lot of legal theorists, myself included, think that the abortion question really ought to be controlled by some simple words in the preamble of the Constitution. Preamble says that we ordain and establish this Constitution to protect these rights for ourselves and our posterity. Who is our posterity if not those not yet born? That's exactly who our posterity is, those not yet born. I believe that that's extremely important. I think the 14th Amendment right to life is something that unborn children are being deprived of without due process of the law. I think there are open challenges on this. And California needs to understand that if they pass any law which purports to protect a woman's right to an abortion, they're going to be facing legal challenge from organizations like Lex, Rex, and others. On the issue of gun control, I already mentioned every single person needs to apply for a permit. Well, what can you do on an individual level when it comes to the issue of abortion? Well, California Penal Code currently defines murder as the killing of a human being or fetus with malice aforethought. After Roe and Casey have been overruled, that's now good law again, that's enforceable. Now there is an exception in that statute which says that, that you can't interfere with the choice of a woman to obtain an abortion. So I think the language that it uses is basically that you can't, if the woman has directed someone to perform an abortion, somebody can't interfere with that decision. What that does leave open is, and we know this happens, is many pro-choice centers will put a great deal of pressure on women to obtain abortions. They would much rather provide that than the other family planning services that they purport constitute 97% of their business. If we can show that that happened, if we know that happened with a particular person, there actually is a right to pursue possibly civil action against that person, certainly criminal charges. Obviously, prosecutors are going to tell us that they don't have the resources to be able to prosecute these kinds of crimes. Well, there's actually California and Ninth Circuit precedent showing that you can contribute money to prosecutors' offices to do that. So if we want to put pressure on them to do that, that's an option. I don't know that it's our strongest option, but that's one that we can pursue. At that point, if they still refuse to enforce the law, you have civil remedies against them. What else? What other sorts of civil remedies? Well, in wrongful death cases, often you can rely on criminal statutes to find liability. So if a father of a child that did not want to have his child aborted ends up finding out that his child sadly was aborted by the mother, there may be civil rights of remedy that can be pursued now under existing California law. All of these are options that we need to look for, we need to be aware of, and we need to bring to the court if we can do it. Most importantly, the court's repudiation of Roe and Casey leaves open the path for us to defend what the Constitution actually does have to say abortion, and that's that guarantee of our rights to ourselves and our posterity. So who does the Constitution say is ultimately responsible for guaranteeing the rights to ourselves and our posterity? Joe Biden? The Supreme Court? No. It's actually in the very first words of that same paragraph. We the people. We the people are responsible for holding our government accountable on every one of these things. It's really easy to point fingers. You know, we have some terrible leaders out there, and it's easy to point fingers at them and say, it's your fault, it's your fault, it's your fault. And that's true, and we ought to hold them accountable where they are indeed to blame. But ultimately, it is not worth much if we don't do something about it. We the people are the backstop. And it's also true that our founding fathers definitely built in a lot of ingenious safeguards into our Constitution to prevent power from being abused, but they do nothing if the people don't enforce them. Now, it's hardly our own fault that we're not doing this. Constitutional education has been essentially obliterated over the past several generations in this country. You are not taught the Constitution in the public schools today. I think you have one unit on the founding era in, I think, 5th grade, maybe again in 8th grade. You ought to be taught the Constitution every year. When you're taught a civics class, it should always be in the context of what the Constitution has to say. And Lex Rex is currently working on developing a homeschool curriculum to do just that. If you're interested in hearing about that, you can contact us. But we need to educate the American people about the Constitution. If we're expected to be the referee of what the government does, how can we do that if we don't know the rules? You have to know the rules. That's the most important thing that we can do. It's also true that part of this protection that we do is on the front end. When we go and vote, we've got to be informed voters. But that's not where your civic duty stops. You have to protect against this stuff on the back end too, because nowadays even the fact that somebody got the most votes isn't necessarily a guarantee of the fact they'll get into office. So you got to defend this stuff on the back end. How do we do that? I know it's a word that conservatives tend not to like too much, but we litigate it. The courts were set up to defend our rights. And that's what, prior to declaring independence from Great Britain, that's what our founding fathers did. They filed numerous suits in the British courts. It was only a very last resort that they ended up having to declare independence from Great Britain. Lawsuits are the way that we go about that. That's not being litigious. It's not trying to make a buck. Most of these constitutional claims, we're told we can't even seek damages on them, which is why we need contributions to run our business, because we can't seek money on most of this stuff. We just seek a finding that what was happening was illegal. And when you go and defend your rights, because we're a system of precedent where individuals need to go and present their case, defending your rights, if that gets defended, defends everybody else's rights too. So we do need people who are willing to do that. And, I guess the question back in everybody's mind, can we win? Originally, I planned tonight to tell you about a lot of the cases Lex Rex have been working on, some of the victories that we've had recently. I won't get into that too much since my time is probably, it might be over actually already. But we've been working on some free speech cases. Currently we have a client whose daughter painted a picture for a friend. And the picture had black kids, white kids, brown kids, all different color kids playing together. And it said, "Black lives matter, any life matters." And she was punished for this by her school. She was deprived recess and told that she had to apologize, and they made her apologize in front of 150 other kids at this school. So that's an egregious deprivation of her rights. It's a public school, yeah. It's a public school in Orange County, believe it or not. And of course, we have election integrity. We have a number of cases pending on that issue. I won't go too much into depth on them. That's probably our biggest push right now is on election integrity. We're partnering with the EIPCA, the Election Integrity Project of California, and we'll be giving a supplemental program to theirs where we give sort of tips and tricks, things to look for when you're poll watching, because they give the comprehensive, here's how to be a poll watcher. Well, we want you to actually be effective as a poll watcher, so here are some of the common problems that you'll see. And we're going to give a seminar on that. We'll be sending out information on that in our newsletter if you want to sign up for that. And a lot of other issues too. I won't go over all. Actually, a big one is COVID-19, and specifically medical freedom, we've had dozens of people call us saying, my employer is telling me I have to get vaccinated against COVID-19 or I am going to be fired. Of the people who called us trying to get accommodation from that, about 90% of the people we wrote letters for kept their jobs and were able to continue working in peace without having to get vaccinated. So that's a huge victory there. Most of our clients aren't wealthy people, I already mentioned that, and they don't stand to get a big payout from winning their cases, so we do need contributions to support that. But ultimately, I'll conclude with this. As much as we love winning our arguments on Facebook, that's not how we protect our rights. We protect our rights by getting the courts to recognize them. And LRI is here and prepared to defend you in doing just that. Even if you don't feel that your rights are currently being threatened or you're not in a position to defend them, we ask that you consider contributing. Your contributions will be used directly to lighten the load of those who are bringing actions to defend all of our liberties. America exists only because people were willing to defend their rights within the legal means that they had. And they founded a country where people wouldn't have to take up arms to do that. They did. They were not able to solve their rights within the legal means. We have far more rights than they did when they separated from Britain. We have legal means to be able to protect our rights still. America will continue to exist as long as there are people who are willing to follow in their footsteps and stand up to government abuses. It's not easy, but it's definitely a lot easier when you have somebody else in your corner. That's why the Lex Rex Institute exists, and our Constitution can be defended. We're excited to do that with you. We hope that you'll join us.